Hello, everybody, and welcome to the show, Triple F, Faith and Family First. I'm Eva Andrade. I am your host. I'm here with co-host Jim Hochberg, and we're going to be talking about whether the recent Supreme Court decision on abortion affects minor laws right here in Hawaii when it comes to abortion. So let's chat about that.
Well, hello.
Jim Hochberg, you look so fresh today.
Fresh, eh?
You look fresh.
Fresh as paint.
You look good. So, Jim.
So I'm going to have to spend some time explaining this case.
Yes, you are. But before you do, the reason that I wanted to talk about this today, first of all, let's throw a couple of things just out there, okay? Our abortion shows that we've been doing, and I already know that YouTube is going to put their little thing on the bottom, but I want you to know that the count was going down every time we did a show on abortion. Less people watched it.
So this isn't a show about abortion.
So yeah,
this is a show about how utterly stupid Ketanji Jackson Brown is on the Supreme Court. That's what this show is.
And Jim is not speaking on my behalf. So those people that are going to send hate letters, make sure you address it to jim@jameshochbergerlaw.com. Okay, so let me talk about the story first, and then how we got here. Okay, so there was a 17-year-old girl.
Did you actually read the Eighth Circuit opinion?
I did.
Okay, because that's where half of the story is.
Yes. So, but I think the legal, because Hawaii passed SB 1, as everybody knows, and immediately there was a lot of misinformation, Jim, that went out on the minor issue about here in Hawaii whether minors can access abortion. And several people contacted my office saying, why didn't I tell people that SB 1 opened the door for minors to get abortion? And I was kind of upset about that because
Who said that?
I had people that called and emailed me because they were
Don't they know that's been the law for like a long time?
No, because there is misinformation there. For some reason, there was some information that was going out telling people that SB 1 created that. Now, SB 1 did not create that. Hawaii has had the law on the books for several years now that a 14 and a 15-year-old can get an abortion in the state without parental consent. Now, what's interesting, though, is that and I know that you and I talk about this all the time, in those introductory remarks to bills, right? I mean,
in the preambles,
right? In SB 1, they mention that minors can access abortion. So I think people are assuming that that's where that came in.
Okay. If your church doesn't know how to read bills and how to understand legislation, would you please contact Eva Andrade at Hawaii Family Forum and schedule a seminar that we will do for free to teach you how that works, so you don't have to get upset about things that aren't being changed that are already in the law.
Well, the good side to this is that people are now finally becoming aware that Hawaii is such a liberal state when it comes to Hawaii and what that means. And so I think it's good that we're having the conversation, but I'm going to say this until the Lord calls me home. We have got to speak to each other with respect. And I'm so tired of being attacked from both sides because people think I'm not doing enough or I'm not doing too much or whatever. I mean, the Lord calls us all to do whatever he calls us to do, and he's going to give us the grace and mercy to get through it. So if somebody's listening right now, I'm encouraging you to spend time in prayer to find out what it is that the Lord's calling you to do and go out and do it, because you're going to get that blessing just from doing what God has called you to do. Jim is doing what God called him to do.
So I think the way we need to approach this is from the top down instead of the bottom up.
Meaning what?
Because if we start with the story about the girl, it totally misses the point.
Okay, then I will follow your lead.
The story needs to be Ketanji Jackson Brown, the newest Supreme Court justice, who in her confirmation hearing said she's not a biologist. She doesn't know how to define woman. That's who we're talking about.
Did she use the word woman in her report?
Jim, I don't know.
That's hilarious.
But that's who we're talking about, okay? And she was the only Supreme Court justice out of 9 that disagreed with the other 8, which means the 6 conservatives and the 2 other liberals all agreed.
Even Kagan, yeah.
And she wrote a a waste of 4 pages of time.
Well, and I wanted you to explain,
Yeah.
like you said, the
So-
whole legality of this, because people were assuming, right? Again, people they don't get the full picture; they get part of it, and they're like, "Oh, this must help us with our
it has
minor
nothing
law."
to do with abortion. This has absolutely nothing to do with abortion law.
Okay.
The resolution of a case that started out about abortion has nothing to do with abortion. But here's what happened. At the U.S. Supreme Court on March 20th, 2023, 8 of the 9 justices agreed to take the appeal, but not rule on the appeal. Instead, vacate, which means cancel the Eighth Circuit Court of Appeals ruling, and dismiss the case completely, because the issue was no longer a legal issue. It was moot.
Well,
Okay? So what the U.S. Supreme Court, 8 out of the 9 said, this case has been coming up the ladder for all these years, but at this point, it's no longer a case. So we're going to cancel the entire thing like it never happened. She didn't like that. And so she wrote 4 pages why the other 8 were wrong.
And I want you to get into that because I think it's important. But again, for us
now
people,
go ahead and start at the bottom and work your way up.
I will do that, but I want you to explain something a little more clear, because you, as an attorney, you live and breathe the justice system. So you could probably go to sleep at night and see little judicial sheep jumping around in your head, right? I mean, you get it. But for those of us,
I think the lawyers are more like lions than lambs.
Depends, right? Okay, so let's understand this. So I'll explain the story that became the first case, right? Because everything has to start from a first complaint or a first.
And then save about 5 minutes, because I do want to talk about what the implication is of how this went.
Okay, so as you know, you never get the person's real name. So in this case, Jane Doe was 17 years old, and she discovered she was
pregnant.
She was pregnant. Okay, and this
which means she's not a man or a woman. She's a pregnancy capable person.
I saw the word "she" in the documents I was looking at. So anyway, then this was in December of 2018. So it's basically, in the state of Missouri, you have to have parental consent in order to have an abortion.
No,
but you can go.
It's notice, not consent.
But you can go and do it on your own, but you have to apply in order to do this, right? So the way that they describe this,
there's a string of cases in the 50 years of Roe that dealt separately with parental consent
and
versus
notification.
Parental notification.
Right. So,
this was notification.
Right. So I'm looking exactly at the Missouri law right now, right? And it says that and this is in their 188.028.1, a minor may bypass this requirement by obtaining a court order granting the right to self-consent for mature minors, or judicial consent for best interest.
Correct.
So she realized that I can't get,
but that
without
still
notifying,
requires
right,
notification in the process.
Right. So obviously she must have been told by Planned Parenthood what to do, because a 17-year-old went to Randolph County Courthouse to apply for a judicial bypass. Now, most 17-year-olds would not know anything about that. So
if they went to Planned Parenthood, they all would.
Right. So then they would have encouraged her to go do this.
And the ones that don't want abortions are the ones that don't go to Planned Parenthood. All the other ones go to Planned Parenthood.
Right.
Yeah.
So an employee at the clerk's courthouse
Chapman
wasn't sure about her being able to do this, and so she told her to come back and she would give her the information. So when she comes back a few weeks later, the employee tells her that, quote, they were pretty sure that she could not open the petition without notifying a parent. So there was some come back and find out more information, but basically in March of 2019, she ends up traveling to Illinois, where she got her judicial bypass in Illinois and then had the abortion without parental consent or notification. Now she goes back and she sues Chapman.
Before you move on, the problem with this case is the looseness with which the Eighth Circuit covered exactly what you said, because the clerk did not tell the girl she couldn't open the case without notifying the parent. That's not what she told her. And if you look at section 1 of the opinion, it says that she testified, Chapman, the clerk, she chatted with the judge, and his words were, he would require us to send notification to the party. She added that the judge advised that he would not hear the case without giving notice. So Ketanji Idiot Jackson Brown changed that for her convenience. And when judges do that, it's wrong. So what they told the girl was, if you file your petition before the judge hears your petition, you're going to have to give notice of the hearing to your parent.
And every parent listening right now is going, well, hell yes,
exactly.
We want to know. I mean, I don't, this thing, we are spinning around on words and whose opinion and whether someone's a Democrat or a Republican. But if you cross all of that out and just sit in front of a parent is going, would you want your minor child to be able to have a court case without you knowing anything about it? Now, let me throw this out.
But before you go past that, a minor can't bring a court case until they're 18 years old. If they get injured and they want to sue over it, it gets brought by their, quote, next friend, which is their parent, their aunt, their uncle.
Unless they've been emancipated, right? Because an emancipated minor
that happens
could.
So rarely.
Right. Okay. But the point is that, parents need to be aware of what's happening with their kids. Now, having said that, I want to make sure, again, that I don't get any nasty email. I get all the nasty email. You don't get the nasty email. But I understand that there are some families out there where it's broken and you've got maybe drug addicted parents, or you've got absent parents, or parents that have domestic violence. But we have a system in place for teenagers that are experiencing that kind of situation.
Giving the parents notice of the hearing. The parents don't have to come. They just have to get notice that it's happening. If the parents come, the test for the judge is the kid mature enough to make this decision? And if I don't think she's mature enough to make the decision, is it in her best interest that I rule she can get the abortion? The parents can show up and participate in that inquiry.
Well, I think we'd be worried though about maybe a 16-year-old girl whose father, maybe she doesn't have a mom around, but she has a dad and he's an alcoholic and he beats her all the time. I could understand her not wanting her father to be notified about this because she doesn't want to get beat. So what I'm just saying, that I understand that these are all exceptions, right? But so the point is, I want people to understand that you and I do have discussions about potential, people that may not quite fit in the mold. So we're not trying, I guess what I'm saying is we're not trying to beat everybody up over this. I mean, we understand that there are stories that
I don't ever beat up anybody.
Well, I know that. I know that, but I'm trying to get it out there so that they know that, because not everybody does. Okay. So basically, so that's what happened. So she sues Chapman in both her individual and official capacities.
Well, she sued. And here's the interesting thing. She sues because she's claiming that Chapman was operating outside her official duty because she misstated what the rules were. And the girl wanted damages because she'd already gotten the abortion. Mm-hmm. She wasn't trying to get the bypass of her parental stuff. So she wanted the clerk to be sued to pay her money so that clerks don't do this anymore. Mm-hmm. Okay. And what's very interesting about that is government employees have immunity from responsibility if they're doing their job properly. If somebody said this is your job and that's what they do, unless it's, obviously and patently illegal or something. The old, I was following orders in the concentration camp. Right, obviously, that doesn't apply. But if you do what you're told in your official capacity as the clerk, you can't be sued. You're immune from the suit because you're a government worker. Why are you responsible for the rules in the government? So they took the deposition of the judge that she said she spoke to. And he didn't even remember the thing happening. He didn't know the girl's name. And all he could say a million times is, I really don't have a present recollection of what we were talking about.
Oh, God. I'm having memories of really bad congressional hearings. Oh, geez.
And so what people that were all upset about this case don't understand is the girl that wanted the abortion sued the clerk for money for acting outside of her authority in denying the process. You file a lawsuit and you do discovery. You take depositions. You find out, is she or is she not within the authority of her office?
And you love that part of a case, don't you? The whole discovery part.
Then, once the discovery is done, if you think you can avoid the trial because you got the testimony under oath that you need to win at trial, you file a motion for summary judgment asking the court to rule in your favor based on the sworn testimony, because there's no longer a question of fact as to what happened. So they were using this judge's deposition testimony, which was mostly, I really don't know what we're talking about. I have no recollection of this event, from 2018 or 15, whatever it was. And that the issue for the court was, did that raise an issue of fact? Because he doesn't remember, did he or did he not tell the clerk to do it, right? If he told the clerk to do it, she wins by immunity. And if he didn't, and she was wrong, she loses because she was outside. So anyway, this case was at the very beginning where they were trying to decide whether the girl wins on summary judgment without a trial. She won on summary judgment, so the clerk appealed to the Eighth Circuit. So take it from there.
Well, I love it because when it got to the Eighth Circuit, I had to go look this up because I thought this was fascinating. And it also ties into the fact that right here in Hawaii, they're trying to amend our Constitution to add reproductive freedom in there. And this kind of, it ties in a weird way. So one of the things they brought up under the Eighth Circuit was that it was attacking her rights according to the 14th Amendment of the Missouri Constitution.
No, the 14th Amendment of the United States Constitution.
So I had to pull it up.
That's what Roe was hooked into.
So I pulled it up, the 14th Amendment, because I want people to know this is
the 14th Amendment is where the penumbra rays of the umbrella of liberty were found in Roe by the Supreme Court.
Right.
The 14th Amendment, that's it.
So here's the actual words of it. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside.
That was about slavery.
Okay. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws.
And so when Roe was trying to decide if criminal laws about abortion were constitutional, they hooked into that deprivation of rights and said, in the 14th Amendment, behind a cloud, there are rays of light that show that are penumbras of the liberty interest, and therefore you can't deprive a woman of an abortion under the Constitution.
And here's why we're watching very closely Senate Bill 1167, because if the Constitution in the state of Hawaii gets amended to include the vaguest of all terms in the world that actually, in my opinion, is just as bad as penumbra, what does that mean? What and how do we define reproductive freedom? Well, what's going to happen, and you said this in the hearing, well, what's going to happen is attorneys are going to come up with court cases to say this fits in there, and the wonderful Ninth Circuit is going to decide. Well, first of all, it'll be the Hawaii Supreme Court, right, who will decide something. And then if people disagree, it's going to go to the Ninth Circuit.
I'll go to the U.S. Supreme Court.
Or
you
US
jump
Supreme
over
Court.
all that stuff
Okay.
if you're doing
if you really want. Okay, but so the point is to know what's in the Constitution, not only our national Constitution, but our state Constitution, because it does affect rights. Okay, so anyway, the Eighth Circuit, she wins in the Eighth Circuit.
Correct. And after the Eighth Circuit, the Supreme Court of the United States ruled on Dobbs, which said abortion is not a constitutional right under the 14th Amendment. Aha! So what happens? This is very interesting, and it's why Ketanji Brown is such an idiot. The parties to the case agreed to dismiss it.
Well, I had to laugh. Okay, so
they agreed to dismiss it.
I know, but they
and she said it was wrong to voluntarily, and I'll tell you why.
Well, okay, but tell me why after I tell you now that you're right that both attorneys agreed to dismiss it.
Both parties agreed.
But for different reasons.
Correct.
And so, let's understand that, yes, they both agreed, but they agreed. So Doe's lawyers argued that the case is moot, that it's no longer a live dispute because Chapman and Doe had later agreed to dismiss the underlying district court case. Because Doe's lawsuit against Chapman has ended, they reasoned, it does not matter whether Chapman is immune.
But let me tell you what's not stated. After Dobbs, when the 14th Amendment no longer supports the penumbra to hang the Christmas ornament of abortion on the Constitution, all of a sudden, the parental notification requirements, the parental consent requirements were at risk of the Supreme Court saying,
bing, bada boom.
You don't have to do this anymore because there's no constitutional right to abortion. And it's because that was the risk that Miss Roe, or whatever her name was, Jane Doe, agreed to she didn't want to win her case anymore because Dobbs indicated Planned Parenthood was going to be up the creek without a paddle on cases like this all across the country.
Right. Okay, so the Supreme Court gets it, and the Supreme Court remands it to the, so basically, like you said, they say this. So explain that, because in Ketanji Brown's her 3-page dissent or whatever, she brings up this Munsingware vacatur. Okay, so what the heck? I mean, Jim, what is that?
So a lot of times, if a case becomes moot by the time it gets to the Supreme Court, it's no longer a case. So it shouldn't be a case in the lower courts either, because there were rulings and things. So the way you erase it is by vacatur. It gets vacated. It's erased. It never occurred. It has no legal effect. It's an equitable remedy out of fairness to parties because things happen in life after a case gets started. It recognizes in some cases, under the Munsingware standard, that it's more fair to make the case go away, so none of those orders mean anything.
And where does the Munsingware come from? It was a case?
It's a company, Munsingware. Remember those polyester Munsingware shirts?
No.
Anyway.
I do not.
So I don't know if they're still in business.
Okay.
But apparently there was a case that they were involved in as a company. And after the case had been moving, it got to the Supreme Court and it was moot. And even though in that very case, the court did not exercise vacatur, they talked about why sometimes it's appropriate, even if not in the Munsingware case.
So that became the standard.
Correct.
Okay. All right. So that's basically what happened. So the Supreme Court basically, they didn't make a rule. And I think that's some of the misinformation going around. It's not like they made a ruling that now people can tap into that says this means this or this means that.
Well, yeah.
Or does it?
Well, no, the case has no history.
But you were talking about ramifications of this.
Well, and I think what's interesting for people to actually grab onto is, I agree with you, she was probably an agent of Planned Parenthood at the beginning.
Well, so was it Jane Doe way back in Roe versus Wade.
And her Planned Parenthood or other identified mentors that were pushing her to do this case, when Dobbs hit, they got very worried that this case was a trap door for all the protections that 50 years of litigating what is a undue burden on a woman's right to an abortion. When there's no longer a right, do you want a case at the Supreme Court that can eliminate consent and notification requirements because it's not a constitutional right? And I think they flipped out and got her to get rid of this case. And that's the thing. When Roe happened, We had 50 years of litigation. States wanted to regulate abortion within the parameters of the undue burden standard of Roe and Casey and all that stuff. So states kept doing it. Planned Parenthood sued every time. It would get up to the Supreme Court and they'd make their rulings. And so now there's these other kinds of cases that are come up because there's this whole judicial philosophy hanging Roe on a 14th Amendment that no longer supports it. All those 50 years of cases are now exposed out there.
Yeah, to stay on top of all this kind of stuff. That's why I'm hoping that people actually tune into the show because, we're going to give them a side to some of this stuff they may not know. And maybe they know part of it. I know I'm one of those people that I have just enough knowledge to be dangerous. I admit that. So,
well, I'm retiring. And before I retire, I want to file a lawsuit where I get to talk about a penumbra of something.
Oh, do you?
I want to.
All right. So if you're watching right now or listening and you want to be that person to give Jim that show or that chance, make sure you email him at jim@jameshochbergerlaw.com. And meantime, make sure you continue to listen to the show. But Jim, we have a little tiny bit of time. And I'm just curious, what your thoughts are, because you said something in one of the hearings on abortion this session that I thought was powerful, because I think a lot of people, when they think about abortions, and they try to be fair. So I am talking to the fair viewers out there, right? People that maybe have a position one way or another, but they're still respectful. Okay, I'm talking about those people. You said that when it comes to abortion, an 11-year-old can get pregnant.
Correct.
So in the state of Hawaii right now, abortion law, 11, 12-year-olds cannot
13-year-olds can't get abortions without consent.
Or 13 without parental consent. The question is, when is that question going to come up, though? Because this 11-year-old or 12-year-old, they have reproductive freedom, too. So
well, if we amend the Constitution,
Jim, speak to that.
If we amend the Constitution to say what it looks like the amendment is going to say, basically, the state cannot do anything to interfere with any individual's reproductive rights.
They tried to trip you up,
including abortion.
They tried to,
but hang on. If that's what we put in the Constitution, then that means anything that's in current law that interferes with an individual's reproductive freedom, including abortion and contraceptives, it's unconstitutional. So the age restrictions on abortion without parental consent, we actually could find ourselves in back alleys with coat hangers, because if reproductive freedom requires that, you get it.
Well, we're going to end on this powerful note right now. We want you to like, share, subscribe, hit that notification button so you know every time we upload a video. And the other thing that we want you to do is we want you to stay plugged in, because Jim is going to be given the gavel on the next show. And he's going to come down hard on you taking responsibility for this great nation that we live in. So we will see you next week. Mahalo, everybody.
Aloha.